Good afternoon, ladies and gentlemen. Our last couple speakers of the day will be Ms. Janet Heppard from the University of Houston Law Center and Mrs. Chloe Walker from the ABA CILA. They will be discussing attorneys ad litem and how they're needed in state court proceedings to represent missing parties in special immigrant juvenile cases. Ms. Janet Heppard is a clinic director, received a BS in geology from Wright State University in Dayton, Ohio, and worked as a geophysicist for 8 years at Amoco Production Company before returning to school at the University of Houston to attain a Juris Doctorate and an MBA degree. As a law student, Professor Heppard was a recipient of the Simon Frank Scholarship and received honors in legal writing. After working both for a solo practitioner and as a volunteer attorney in the civil clinic, Professor Heppard was hired as a supervising attorney in the civil clinic in 1995 and was appointed clinical director in 2008. Professor Heppard also teaches courses on domestic violence and immigration family law. Ms. Chloe Walker is a senior staff attorney with the ABA's Children Immigration Law Academy. Chloe earned her JD and Master's in Social Work from the University of Houston in 2012, where she worked for the Center for Children, Law and Policy, and served as an editor for the Houston Law Review. Prior to working at CILA, Chloe practiced family law at Gray Reed and McGraw and immigration law at the Tahirih Justice Center, both in Houston. She has also worked within the Texas Child Protection System as a court-appointed special advocate, volunteer, and a social work intern with the Department of Family and Protective Services. Prior to graduate school, Chloe served 2 years as an AmeriCorps volunteer in Austin, Texas. Please help me in welcoming our last two speakers of the day. Thank you.
Thank you so much. I'm really glad to be here today at this training sponsored by the Harris County Attorney's Office because, as was just mentioned, I was inspired to become an attorney and a social worker because of the opportunity that I had to serve as a guardian ad litem, a CASA, for children who are in the child welfare system. So it's the wonderful folks that represent children in CPS cases and the judges that really showed me the power that attorneys and judges can have in a courtroom to make a difference in a child's life. Just major kudos to the Harris County Attorney's Office for the work that you all do. The kids in our child welfare system are incredibly lucky to have you all as your advocates. And I also just we're at the end of the day. You've heard from so many different attorneys throughout the day from different organizations. And I just wanted to give a major kudos and shout out to the attorneys from KIND, from Cabrini, from the YMCA, from Tahirih Justice Center, who am I forgetting? From CILA. But no, really, to the folks that are on the ground representing kids, because as so many people have mentioned throughout the day today, there are no court-appointed attorneys for children. There are no government-funded attorneys for children in this system. And the nonprofits and the attorneys who work at the nonprofits are the ones doing this work on the ground every day. And it is hard, y'all. It was hard, 3 or 4 years ago, and each year it gets harder and harder. And I feel privileged to be in a position now where I'm at CILA, where I can, have the time and the resources to really stay up to date with what's happening and the changes in law and policy so that I can try and make it easier for the folks who are on the ground, like I was when I was at Tahirih, because it's really hard and folks are working really hard. And, we all work at nonprofits, and we are funded through federal money, through state money, through foundations, and through individual donors. And so Dahlia, Anne, Desiree, Claire, Chicky, they're all out there every day, spending a lot of their time looking for more funding to keep the doors open so that we can keep representing kids, because it's not government funded and because there are no court-appointed attorneys. So I just really wanted to give a shout out to all the folks that have spoken today and for the hard work that they're doing. And that leads me to also be grateful to be sitting next to Professor Heppard, who has been an amazing and huge ally for those of us who work in the immigration field. at U of H, she is an expert and works every day in the field of in civil law and family law, and especially about 3 or 4 years ago, as more and more kids were eligible for and going into state court to get special immigrant juvenile status, we really leaned hard on the experts and professionals like Professor Heppard, who knew how state court worked, and also, was able to work with and understand immigration issues and how that intersected. So we're so grateful that she's here today to talk to you all about how to be an attorney ad litem in the state court system. Again, as you have maybe has been driven home today, there are so many different systems that unaccompanied children have to interact with on a daily basis, and the state court system is just one of them. And especially for those kids who don't know where their parents are, we still have to overcome this hurdle of due process and service and making sure that their parents do have the ability to know what's going on in state court. And so sometimes that involves the assistance of the appointment of an attorney ad litem to try and locate that parent. And so that's going to be the bulk of what Professor Heppard's going to talk about today, not just through her experience in state court, but serving as an attorney ad litem and working with students who play that role often.
Well, and then Chloe's going to give you some examples.
Yeah, and then we'll talk about specifically how that might intersect with different case examples in special immigrant juvenile status.
So I would also like to say this is not our PowerPoint other than the slides at the end. And we want to thank Maisha Coulter, who is the executive director at AVDA, for allowing us to use these slides, because they also do this presentation because they need also attorney ad litems in their domestic violence cases. So the objects of this training is just a general overview of service of process. Most of you should be already familiar with this, unless you're a relatively new lawyer. We're going to talk about the relevant laws and statutory requirements for the cases where we do service by publication, and sort of when an attorney ad litem appointment is required. We'll talk a little bit about best practices, and so what does it mean if you're appointed as attorney ad litem. And then we're not going to review a lot of the pleadings. We're going to talk about them, and I believe those have been put online.
Yes, in that link that you all received yesterday, there's a copy of the PowerPoint, but there's also quite a few templates that, again, were given to us by AVDA.
So the general rules, as you know, is that service of citation is to be used to give respondents notice of a hearing. That citation tells them, right, they have approximately 20 days to file an answer, where they do that, and how they have to do that. And the rule says ultimately they're supposed to be served with a true copy. So what's service by publication? You see the definition up here: serving a summons, a pleading, or another document in a lawsuit on a defendant or respondent by publishing the document in an advertisement or in a newspaper of general circulation. One of the things to know about that, and we'll talk about it again as a reminder, the general circulation is general circulation in the county where the case is filed. And we'll talk about why that's important when we get a little further into this. It really is constructive notice because, nobody's literally serving them with these papers. So we'll talk a little bit more about that. And it has to be done via a judge's order, allowing you to serve other than personal service. As you know, the different methods of service, I could do personal service, and of course that's what's preferred, because we don't want anybody coming back later, or in our SIJ cases, we don't want the government to come back and somehow complain that the person wasn't given proper notice when the documents are filed with immigration. I can also do service by certified mail, but remember that certified mail through the county clerk or the district clerk's office. So that doesn't mean I can do service by myself sending certified mail to the person in question, to the respondent. The interesting thing there, though, is if there's, by some magic way, you get the judge to sign an order that allows you to serve it that way, then you can do it. We have substituted service and alternative service. Up here on the slide, it's noted as also known as alternative service. It's slightly different. Substituted service is really that instead of serving the respondent, maybe there's I don't know where the respondent is, but I know where a family member is. So I do substituted service and I serve that family member instead. And then alternative service, one of those is what's on the list here, service by publication. A couple of laws that relate to that, the specific ones in the Family Code. There's 6.409, we're going to talk about these separately. 102.010, which is the kid part, and then the general rules of civil procedure. So 6.409 is the statute in the divorce part of the Family Code. And it, kind of the special things there is, in general, if I was doing service by publication on somebody in, say, a breach of contract case, I have to actually publish notice 3 times. And this part of the Family Code says I only have to serve it once in these family cases. And you should also know that if there are no kids and no appreciable property, this is for a divorce, then I can do service by posting. And they literally post it on the bulletin board down at the courthouse. If there's no children and no property, I can also ask the court to waive that attorney ad litem. Because normally, any case, when I do service by publication, which includes posting, the law requires that an attorney be appointed to represent that respondent. In 102.010, that's in the child custody part of the Family Code. So if I have a divorce and I have kids, then this also is one of the statutes that you'd need to look at. One of the interesting things here is that after June 1st of this year, there should be a public information website that you can use to publish your service by publication. It's my understanding from reading the statute that you'll publish in a newspaper in the county where the petition is filed, and then in addition, will publish on this state-run website. We'll see how that works. We haven't heard anything about it yet. Yeah, so you should also know in Harris County, most of the time we do publication in the Daily Court Review because it's usually less expensive than publishing like at the Houston Chronicle. If you're up in, say, Montgomery County, you can also still use the Daily Court Review because they also publish up there. And for like you guys, the Daily Court Review will usually give pro bono organizations a discount. You may not know that, but you have to call them.
Pro tip.
Right. So the general rule 109 is the general, where I first look when I'm doing a citation by publication. One of the things that I have to do is I have to make a motion to the court to ask the court to allow me to do citation by publication. What I need to do with that is I need to attach an affidavit, usually from my client. Sometimes it's from the attorney, but it may be from both, saying what I've done to try to find this other person. The court's job when they decide whether they're going to allow you to do service by publication is to decide whether you've done due diligence to try to find the person before you've come and asked for service by publication. The return of the service, this is just another rule that's important to know for the return of the citation. Just like any other citation, it has to be on file for at least 20 days. And then once it's been on file, then the court would appoint an attorney ad litem. Most of the time, we have found I don't have to make a motion to the court to appoint the attorney ad litem. I just, once my 20 days are up, I call and I talk to the clerk to let the clerk know the time period has passed, and ask them, I double check with them whether the court requires a motion or whether the court has their own order and will just appoint somebody. And this is the list that we're going to talk a little bit about having you guys be willing to be on to serve as a pro bono attorney ad litem. In these cases, if there are cases where somebody has money, not the kind of cases we're talking about, the attorney ad litem's attorney fees get paid by the petitioner. One final rule on the Rule 244 just really talks about what's required of the attorney ad litem sort of to finish the case. And one of the things is, at the end of the case, the attorney ad litem files this statement of evidence. If they haven't been able to find the person, they will draft and file this statement of evidence that really, that the court will sign and approve, showing what it was that the attorney ad litem did to try to find the respondent. Oh, one other thing on that is we tend to find that the courts want this statement of evidence filed prior to the hearing. So that all gets e-filed. So hopefully everybody's familiar with the e-filing system. And if you're not, just because you don't really use it, then these guys are all here to help with that. So just kind of a summary here. If there's no children or no children under the age 18 and no property, the court can actually waive the ad litem, and you have to do a statement of evidence. This is if you don't find the person. If there are children, then the court's required to, or there's what they deem substantial property, then the court's required to appoint an ad litem. What we've tended to see, even when there are no children or substantial property, is the courts still tend to appoint an attorney ad litem, even though they could waive it. Especially if they see a lot of these cases where the parties are pro se, and the concern is, well, maybe there actually is property out there that they're not telling the court about. So just as a kind of follow-up on the summary of the laws, an attorney ad litem must be appointed for a parent cited by publication. And this includes if somebody is, it's a CPS case and they can't locate the parent. It just depends if that parent, we're not going to get into this and maybe you've already talked about it, whether the parent's an alleged parent or whether that parent is a presumed parent because the child was born while they were married. Because it actually does make a difference. And an attorney ad litem must be appointed for the missing party unless the suit is one for divorce annulment or to declare a marriage void, and the petitioner or the petitioner's attorney makes an oath that there are no children and no appreciable property. Okay, so what's an ad litem? We have different kinds of ad litems. One is an attorney ad litem. That's what we're talking about. You actually get appointed to represent that respondent or defendant as their attorney. So just like in any other case, when you're somebody's attorney, you have the same obligations to that respondent that you would have now here as an appointed attorney ad litem. We also have amicus attorneys, and I don't know, did you guys talk about those?
We mentioned the word amicus attorney, but
so if you're an amicus attorney, an attorney is appointed to represent the child in a case, but you're not appointed as their attorney. You're appointed to represent their best interest to the court, which also means as an amicus that you have no confidential relationship with that child. If you're an attorney ad litem, you do have a confidential relationship with this person that well, you may not be able to find them, so it may not matter. Then there's also a guardian ad litem. The guardian ad litem is appointed to represent the best interests of a child, and mostly those are used in Children Protective Services kind of cases. Once in a while, a court will appoint a guardian ad litem to represent an incompetent parent in a divorce or a custody case. So we've done that, and you could always call us if you have an interest in doing that, or you get appointed. Why do we need, what are we using these pro bono attorneys for? If the parties have children born during their marriage and I can't find the spouse, then I would need an attorney ad litem. These most often occur for pro bono in the kinds of cases that maybe AVDA has, versus the kind of cases that Chloe and I are talking about. If the parties have any amount of appreciable property, then the court, and I'm doing service by publication, then the court has to appoint an attorney. For the cases we're mostly talking about is here, this number 3. The child has been abandoned by one or more of their parents and is eligible for this special immigrant juvenile visa. So it requires a family court order that you've already talked about as part of the immigration application. So once I get into family court, then I may have to do, if I don't know where these other parents are, then I'm going to have to do service by publication. One of the things to know, again, we already talked, for a service by publication on this kind of case, sometimes the courts will want you to publish in the country where you think that where that respondent might live. That's not what the rule says. The family court rule, the family law rule says that you have to publish in the county where the case is filed. So that sometimes becomes an issue. You should also know that if you're appointed, I should be over here, that if you're appointed as an attorney ad litem, an amicus, or a guardian ad litem, that you do have immunity. So essentially, you are not liable for, like somebody can't sue you, you're not liable in terms of malpractice unless you just so neglect your duties. It's a very high standard. So that should make people feel more willing to come in and help with these kind of cases, because although anybody could sue, they're not going to win on these cases, because you really have to mess it up it's a really high standard for you to have any kind of liability. Okay, so let's talk about, you get appointed as an attorney ad litem, now what happens? So the first thing I do is file an answer. I believe in the documents that have been loaded is an answer that you can file. It's really a general denial answer. That's all we do on those cases. And more than anything, that just gets your name attached to the case. My job then is to investigate and try to see if I can find this person. So a good place to start is to talk to the petitioner. Remember, though, if the petitioner has an attorney, then I need to get consent from that attorney before I can talk to the petitioner. Just like in any other case, I'm an attorney on the case, this person's an attorney, so I can't just randomly call and talk to their client without their permission. We've not had that be an issue, and most of the time, the attorneys just give their permission, and then you set up. Frankly, we have them come to our office. We don't go to them. They can come to our office. And you just need to think about what kind of questions can I ask them to try to help find this other person. And those, besides getting name information, if they're in a foreign country, then it's much more difficult to look for them anyway. But sometimes they do happen to be in the U.S., so I can look for driver's licenses, any other kind of licenses. A lot of times you can talk to them about whether they have a Facebook page. We found a guy via is LinkedIn. So sometimes I can use that because those are other ways then I can go to the court and say, look, we know that this Facebook page is this person's Facebook page because we see pictures of them. We see pictures of the child on this Facebook page. And if I can't get any kind of address, then sometimes I can go back to the court and ask them to give me an order that allows me to post and serve them via their Facebook page. We've also done it when we've been appointed attorney ad litem. We get the person's email from the petitioner. Say maybe the petitioner's been emailing them, but they don't want the petitioner to know where they are. So I've emailed them because now I'm court appointed to represent them. And if I can get a response, then I can, and where I know that that's a valid email, then I can go to the court and I can ask the court, if that's the only way to give them notice, I can ask the court to allow us to do service of citation via their email. So that's also worked. And you just need to think about, work, where did they go to school, did you guys have any common friends, all that kind of information that you then might be able to use to get in touch with your client. We tend to find that if you're appointed as their attorney, a lot of times they're more willing to talk to you than they might be because they're trying to hide from the other side. Sometimes I don't actually get an address from them, but I get enough information that I can turn over so that there can be actual service. There are times I also am able to convince that respondent to just file an answer. And I'll email them an answer if they'll file it, and that brings them into the case. So that ends up being, that is helpful. The goal is, you just always need to keep in mind, the goal is to give this person notice of the lawsuit. However, I can best do that. And of course, because the publication itself, frankly, who reads the Daily Court Review? How many of you have ever read the Daily Court Review? We do get it delivered to the law school at U of H, but nobody reads it there either. So we all recognize that that's not really a valid way. That's not really going to get them any kind of notice. One of the other things that you want to do is to also check criminal records, because and sometimes we check them, once, and then we check them again, and the second time, well, now they're in jail. So then it makes it a whole lot easier to serve them because now they can't hide. If they're in jail, a lot of times, or I think I have found them in jail, I'll send them a letter, right? They can't get emails, but I can send them a letter and say something to the, like, we've been appointed to represent this person in this custody case, and I usually give the other adult. I don't necessarily want to put in there because I'm careful what I put in case it's not the right person. I don't put the kid information. But then sort of, if you're this person, please contact me back. And we do find if they're in jail that they usually do contact us back. So we talk about interviewing the petitioner, and one of the documents that was uploaded should also give you some more ideas of questions to ask the petitioner, because they're really your first line person on trying to get information. We also have some different documents, so different methods. And you guys probably know I'm a bit IT challenged, so I'm not always very good on the internet. But talk to your kids and talk to your younger staff, because those guys are really good on the internet and can also give you other ideas of other potential websites where somebody might be. We've already talked about filing the statement of evidence. That statement of evidence really is what lets the court know what you did to try to find this person, and sort of it finishes with, I think I've done everything I can and I haven't been able to find them. We do find that probably at least half the time, we're able to find the persons that we're appointed for. It's much more difficult in these special immigrant juvenile cases, but sometimes you can contact some government agency in the country where you think they are, and they actually are able to locate them. So some of these dads that we've seen have been like in the police department down there, and so we're actually able to find them. So think of those kind of things too on contacting people in the country. You'll also find for the special immigrant juvenile cases that the petitioner often can give other family members who are back in the home country that you may also be able to contact to be able to locate them. If you are, if you're not a Spanish speaker and you're trying to talk to somebody in the home country who's a Spanish speaker, I believe that you can probably use the State Bar
The language line.
line. I could think it was legal line, and that wasn't it. The State Bar language line to help to have a translator. So that is helpful. Now, the next step here that's listed is to file a motion for an oral hearing regarding your findings. Most of the time, that's sort of done, if I don't find the person, that's usually kind of done at the same time as I go into court to finish the whole case. Because if I haven't found them, my job is to still represent their interests as best as you can. And so you just do that at the same time as the final hearing. If I find them, and I think one of these talks about, oh yeah. So if the party is found, then I'm going to file, I give the address or the location to the petitioner's attorney, and then it's their job to get them actually now served in person. Sometimes I will say on the stuff that we do, because then your job is done. On some of the stuff we do, if we're attorney ad litem and we feel that with just a little help from us, we can get this case taken care of, then because these people don't have money, then a lot of times we will continue to help the respondent to finish the case. If it gets real contested, then we also withdraw, but that your job is done. Again, if the party's not found, then I have to do the statement of evidence, and when we go in for the final hearing, that's when I usually let the court know that I haven't found them, and I put my evidence on as to what I did to try to find them, and then the court will accept that, and then they go ahead and it's sort of a default, but it's not a default because I represent them. The main thing that I find if I'm representing the respondent and I don't find them on these special immigrant juvenile cases is making sure that you know whether that person, are they an alleged father or are they a presumed father. So if the parties under Texas law or the law of that country. So if the parties were married at the time the child was born, then they're a presumed dad. It is what it is. If the parties aren't married, then usually they're an alleged father. But what we've tended to see, and you need to look at the law of the country where that child was born, and look at the birth certificate. So if they're on the birth certificate in most of those countries, even if they weren't married, that country presumes them to be the father. Because I cannot, the court can't make a finding that this respondent is actually the father if they're an alleged father and they were served by publication. That it makes sense, right? You don't want somebody just giving a name and saying, well, this person's the dad, and then the court does something with that on a court hearing. So I can't, through service by publication, I can't make a finding that somebody's a dad unless they're a presumed father. So you need to keep that in mind. What happens, again, if they're an alleged father, my job is to make sure then that the court doesn't name them as a presumed father, but it also means that the petitioner is going to have to go back and also file for publication against an unknown dad. And most of the attorneys that you're working with who are doing these cases are going to know that. And the court, well, if you go to your final hearing and you haven't done that, the court will probably make you do that.
And if you have questions about it at any point during the process that you want to ask someone who's not involved in the case, you're always welcome to reach out to CILA for technical assistance.
Yeah, these guys do a great job. We're happy to answer questions too. Okay, Chloe, it's you.
Okay, so how does this come up? I can't read that far away. I just wanted to highlight a few examples of situations where you might find yourself either being the pro bono attorney representing the child, or a child who might need a pro bono attorney ad litem in their state court case. So these are all anonymized. These are not real cases. They're just combinations of facts, and these are not real photos of clients. So Dennis is 15 years old and from Honduras. His father abandoned him when he was 3 years old, and Dennis has not heard from him since. A couple of years later, Dennis's mother left for the United States and left Dennis in the care of his maternal grandparents. He grew up with them. They took good care of him. He studied at a small private religious school, but as he got older, gang members began harassing him on the way to school. At first just asking him for money, but then trying to recruit him. And then about 3 months ago, gang members pushed him into a car, drove him to a field, beat him, and left him there. He was able to make his way home, but his grandparents decided they could not keep him safe. So his mother, who was in the United States, sent for him, and he was reunified with her after being detained at an ORR shelter. So Dennis hasn't seen his mom in 10 years, but he has been in touch with her. She's called him every week and sent money to his grandparents to support the three of them. Since arriving at her home, she's ensured he's enrolled in school, visited a medical clinic, and has provided food and shelter for him. So Dennis is eligible for special juvenile status, but only if his mother is able to serve his father with notice of a custody suit here in Harris County. Like Professor Heppard mentioned, there can be issues that come up if a parent is not on the birth certificate. I'm looking back to see if we wrote whether or not he was on the birth certificate in this fax. We didn't. So let's say he is on the birth certificate, then again, the attorney for the child will be trying to prove to the court and presenting evidence to the court that Dennis's father is his presumed father. And so when an attorney ad litem is appointed and served by publication, they'll be able to move forward with that case. But the point that I wanted to highlight with this fact pattern is that, Dennis, his mother, no one has seen his father since he was 3 years old. So how does he move forward with his case without giving notice of this suit to his father? Well, the court will appoint the attorney ad litem, and as Professor Heppard mentioned, you as an attorney ad litem, you might be able to find him, talking to Dennis's mother, talking to his grandparents, seeing if anybody has any idea where his father is, and maybe he'll be able to find him and give him notice of the suit to move forward. But if no one can find him, including the attorney ad litem, then Dennis and his mother can still move forward with the case, because the attorney ad litem will come as the independent representative and present that statement of evidence to court to allow the case to move forward, the order to be signed, and Dennis to ultimately apply for special immigrant juvenile status with the court. Oops, wrong way. Okay, so here's another example. Nancy is 17 years old. She's from El Salvador. Her mother was physically and verbally abusive and abandoned her when Nancy was 10 years old. She went to live with her maternal Aunt Letty. Her mother actually now lives in the United States, but when Nancy was 15, gang members started harassing her on her way to school. I think I left some stuff out of here, but basically, her caregiver, her aunt in El Salvador, decided again for these that it was not safe for her to be here, that her aunt in El Salvador could not take care of her, so she came to the United States. But when she went through that ORR process, she was reunified with another aunt. So even though her mom is living here in the United States, she went to live with a safe caregiver vetted by ORR, her Aunt Corolla. Nancy's mother currently lives in Maryland. The sponsor, Corolla, last spoke with her 2 years ago, but she does have a phone number and an address for her that she believes is valid. But mother doesn't know that Nancy has come to the U.S. yet. Nancy's never met her father. It's a little complicated because her birth certificate says that Nancy's father was Francis, who's actually her uncle, who helped register her birth because her father was unknown. Her actual father was a man named Jose. Her mother didn't have a long-term relationship with him. It was more of a fling. There also might be circumstances where a child is a product of rape, right? So you just really might not know who the father is. Jose's whereabouts are unknown. Everyone lost track of him a long time ago. No one knows where to find him. So Nancy wants to stay in the U.S. and she wants to stay with her Aunt Corolla, who's a good caregiver. And she fears returning to El Salvador, even though she does miss her grandmother who had been caring for her. So Nancy might be eligible for SIJ status, but in this situation, she would need someone to file a custody order for her here in the United States, so her aunt is probably eligible and has standing to file that custody order, but now she has to serve both mom and dad.
And we tend to find most often the court will, in a case like this, the court will usually appoint one attorney ad litem for both parents.
Okay, to make it,
Surprisingly, because you could say there was a conflict, but if I can't find either one, then they don't worry about it. You know, if I found one of them and then thought that there might be a conflict for the other, then I could ask the court to appoint a second attorney ad litem.
well, so what would you do, Professor Heppard, if you were appointed in this instance for the father? How would you sort of deal with the situation of who the father was? If one person's on...
Well, we've had that come up in cases for that very reason that Chloe's talking about. So usually what we do is we just serve everybody. If aunt testifies, right, mom's not in court, aunt testifies, if aunt testifies this person's not really the dad, in the end, a lot of times for these state court filings, we may have the court makes, in a sense, makes a finding that they're not going to make a finding of who the father really is. Because one person's on the birth certificate, they could still find that they are, because depending on the country, a lot of those countries, if they're on the birth certificate, then they are the dad. But we've had it come up, and most often then we would rather that the family court here make no declaration of who the father is. And 30 years ago, it might have mattered because you didn't want to bastardize a child, but it's just not viewed that way today. And the language you use essentially says this court makes a no finding at this time as to who the father is. We all know there's a dad, and that's okay.
Right, and so, yeah. And if you're representing the aunt in that situation, you also just want to make sure, again, like Professor Heppard said before, that you also have an unknown father on the pleading, so that you can make a finding of abandonment or abuse or neglect as relevant against an unknown father, even if you aren't able to get the court to specify who the actual father is.
Yeah, I could also, if I have access to this uncle, and I don't know if it was, I guess the uncle down in El Salvador, if I have some sort of access to that uncle, then I might be able to do paternity testing. And to be able to show at least that person's not the father. So I can do that. There's a fee for that doesn't get waived. However, we have a contract with LabCorp, and maybe some of the agencies do too, so LabCorp at least gives us a discount.
Okay. Last example, Omar is a 17-year-old boy from El Salvador. He lived with his maternal grandmother and younger sister Nora prior to coming to the U.S. He has no memories of his father, who left his mother when Nora was an infant, and he's not had any contact with his father's family. His mother has lived in the U.S. with what's called temporary protected status for over 10 years. And Omar's afraid to return to El Salvador, again, being targeted by gang members who had actually killed his uncle and his cousin. Again, living with grandmother, made arrangements to come to the United States. because there was no other family members that could care for him or protect him in El Salvador. And other than his grandmother and little sister, Omar only has his aunt, now a widow, and her son Andres, who's 11 years old. The gang members know where they live. Point being, he has no place to go in El Salvador. He's eligible for SIJ if his mother files a custody suit, but he must serve his father with notice of the lawsuit. So this, again, is to highlight if you have a situation where there's no father on the birth certificate at all. And we may have talked about this, a little bit already, but Professor Heppard, if you were the attorney ad litem for that father who's named but not on the birth certificate, I think that's the situation you were just talking about, but to highlight.
So we would want to publish to that father and to an unknown father. But as attorney ad litem, unless there's more proof that they're really the dad, the court can't appoint them, can't name them as the legal biological father. And my job as ad litem is to make sure to represent my client on that way. And the reality is maybe if I was able to speak to him, he'd say, yeah, I'm the dad and I want to be the dad. But I don't know what that is, so I just have to make sure that the law is followed in terms of who the dad is, and knowing that if the dad ever later came up and said, I'm the dad, as long as I've not named anybody else, then potentially he could still come into a case. The reality is that's not going to happen here. You also, once in a while, clients, you'll get appointed on a case and the family members may believe that the person is deceased. So then sometimes you can contact, you figure out, and usually the petitioners know who to contact in that country to see about death certificates. Sometimes there's newspaper articles that show that this person was killed. And so if I have that, then that also, in a sense, means I found them. And not obviously they can't then come into the case, but you just let the court know that I found this death information.
Thank you for that. So, yeah, we're happy to answer any questions. I just kind of wanted to highlight, we dove a little bit into the alleged father and the unknown father situation. That's not the case for every SIJ case. We just wanted to make you aware of it in case it comes up. But there is a list of attorneys that is coordinated by the district clerk's office. It's coordinated by the county or the judges, the family law judges.
The family law judges.
The family law judges. And again, this is the work of AVDA, Aids to Victims of Domestic Abuse, who identified this need specifically for survivors of domestic violence. Again, cases where survivors were not able to move forward and get divorce or custody when the respondent was nowhere to be found. And so really grateful to ADVA for kind of pioneering that space and creating those relationships with the judges where they, are agreeable to appointing people pro bono off that list because they recognize that it is a huge financial hurdle, especially, again, as we mentioned, attorney ad litems for publication are typically paid for by the petitioner, not the county or the court. So on that note, I have 2 clipboards, and I'm going to pass them around. And if you're interested in learning more about getting on that wheel so that you could be appointed as an attorney ad litem in a case, whether it be an AVDA case or an SIJ case from one of the organizations that we talked about before. And the AVDA wheel is often cases that come from the clinic, the U of H clinic, or is it more from AVDA?
It's AVDA cases.
Okay, so y'all get appointed on them.
There's a wheel that any attorney can sign up to be an attorney ad litem on a case where they get paid, and then the courts have been willing to sort of have this separate list of attorneys that are willing to take these cases pro bono. And so what the petitioner's attorney does, be it AVDA, be it CILA, somebody, is when they are, after they've done the publication, they'll ask the court to appoint somebody from that pro bono list. But like, we're not on the list, so we just get calls when they need a pro bono attorney without specifically being on the list. And you can, if the court was going to appoint you and you find, oh, this is just a really bad time for me to do this right now, it is okay to say no, but keep me on the list, and because I still want to be able to do this, because we know how that goes.
Right, so it's a really good tangible way if you're looking for a pro bono opportunity that might be a little bit more time limited, might be, it's really focused on sort of research and investigation. I was on that list when I was a private family law attorney, and the firm that I worked at had like an attorney whose sort of expertise was investigation. So, I worked with him. So you might have some resources at your firm that might also help you go through that due diligence, but it is another important piece if you want to support the work of a case through Kind or Tahare or Cabrini. And I will also just say that we're still in conversations with the judges to ensure that we can, try and make appointments for SIJ cases off this wheel. But it's a really good, shorter way to get involved in a case.
Well, shorter in terms of it usually, it's sort of a time here, and then it's done. Because if you don't find them, then both your job is done, but then the whole case could finish. And if you do find them, then as soon as they're actually served, then you can withdraw, and then still your time is done. And it's a great way to do some pro bono without feeling like, I don't do family law, how could I do that? Or I don't do immigration law, how otherwise can I help?
Right, and good point. If you do find them, you also don't have an obligation to stay on the case and represent them in the suit. You can get off of the case at that point.
Right, and in fact, sometimes if you find them in another country, in their home country, you can get them to sign a waiver that waives the need to serve them, and then even after that, you could withdraw. And I know that we have some waivers of citation in Spanish, and I imagine you guys do too.
Yeah, I think all of the organizations have examples of that. Yep. Any questions?
Are you just so tired? It's still raining out, so don't be that excited about going outside.
How likely is an undocumented child is to have a birth certificate with them?
Birth certificate.
The question was, how likely is a child to have a birth certificate? Oftentimes a child may be traveling with a birth certificate, and it may, it's possible that it may be taken away from them at some point from the government, but especially if a child's been through ORR, then their caseworker at ORR during the reunification process is going to have likely already obtained a copy of their birth certificate, and it'll likely be in their file. So it's actually quite likely that they'll have a birth certificate, and if for some reason they don't, there are also contacts at the different consulates that can help them obtain a copy of their birth certificate.
So they can do that. They can get copies of death certificates sometimes through the consulate or family members in the country. Birth certificate, marriage licenses sometimes, so that it sets up. I know that you do family law, so you understand the presumed alleged thing. And but there's usually places to get those documents. We have found most of the cases they have them.
Yeah, oftentimes a child's going to have a birth certificate. Oftentimes their parent or their father will be on their birth certificate. And Professor Heppard mentioned earlier those legal arguments that can be put forth to establish paternity through that presumption. And again, on CILA's website, on that password protected portion that Laura mentioned earlier, we have some guidance on how to put forth that legal argument.
Okay,
Thank you all so much.
Thank you so much.
I'm glad we don't have afternoon classes.
So as you're leaving, I just want to say thank you all for attending. Hopefully you will attend the second part of the series and the third part, and keep checking your emails. We should be in your email inbox soon. Thanks.
Very nice, thank you.
Yes, ma'am. Thank you for coming.